Carol Beaumont.
Well, while the Minister's still frantically looking for that, and because we are very keen for him to enlighten all of us on what that missing act is, just to repeat that in speaking to Part 4, which is of course an amendment to a whole number of pieces of legislation, including the missing one, which Lynn Pillay, of course, will beaver away on as well while I talk. One of them will find it. There is a prize for the winner of the person who finds it. So the amendments to other acts, Ms Pillay has obviously gone through and listed all of those acts for us, so I won't, I'd rather not do it again. I'm sure the House really don't want me to do that. But just to repeat really that this is an omnibus bill and that one that Labor supports, and this Part 4 really does illustrate the extent of the reach of these changes and the number of different acts that are affected by this bill, and primarily the principal act in each case is amended by different definitions and interpretations. So, for example, if I illustrate that for people so that they get a sense of that, because I'm sure you would really like me to do so, the amendments to the Customs and Excise Act 1996, the change there is interpretation around the definition of a fine, and talks about adding a paragraph that talks about any amount payable under Section 138A1 of the Sentencing Act 2002. Likewise, when we look at amendments to some of the other acts, amendments to the Children, Young Persons and Their Families Act 1989, the act there is amended, and there is an interpretation there put in around the definition by repealing the definition of traffic offence and substituting the following definition. Traffic offence means any offence against the Transport Act 1962, the Road User Charges Act 1977, the Transport Vehicle and Driver Registration and Licensing Act 1986, the Land Transport Act 1989, or the Land Transport Management Act 2003, or against any regulation, rule or bylaw made under any of those acts. And also B, any offence against any regulation, rule or bylaw made under any other act if the offence relates to the use of motor vehicles or parking places or transport stations. So the reason why this multitude of acts have to be changed under this Part 4 is of course to deal with all of the situations where people can incur fines, and also some of the other changes like the Privacy Act, for example. I spoke about at some length when I was speaking on Part 3. There are changes there as well. The Railways Act, that's interesting, isn't it? So that's around the issuing of infringement notices. Now, I won't go through all of the wording there because it's quite a long change there, but puts in a whole new section 100 and talks about the content of infringement notices and reminder notices and what's meant to be in those things. We also have amendments to the Tax Administration Act. That's quite interesting, and that's around the disclosure of certain information in relation to fine defaulters. The definition of fine defaulter is amended. So again, these are all very much consequential changes. They are, if you like, tidy-ups to ensure that these various acts will be able to deal with the changes, the substantive changes made in the Courts and Criminal Matters Bill, which, as we've said earlier, and we agree with those members opposite, is a bill that has a very good purpose, which is to address a general concern about the amount of overdue fines, the dissatisfaction of victims when offenders do not comply with reparation orders, and the frustration of creditors and debtors using the court's civil debt enforcement process. And I think in the course of the discussion tonight in the various parts, including this Part 4, we've seen some real efforts to try and balance up some protections and so on, like people's rights under the Privacy Act, against their responsibilities to pay fines. And certainly most of us in this House do believe that it's important that when fines are given for various offences and so on, that people do actually pay those back. That a failure to do so not only builds up a huge amount of debt, which has problems both for the individual and for their family, but also undermines the legislation and the standing of the law.
Members, we come to the vote on Part 4. We first have the Minister's amendments as set out on SOP number 244 to the amendments set out on SOP number 202. The question is that the amendments be agreed to. Those of that opinion will say aye. Aye. Contrary, no. The ayes have it. We now have the Minister's amendments as amended set out on SOP number 202 be agreed to. Those of that opinion will say aye. Aye. Contrary, no. The ayes have it. Members, the question is that Part 4 as amended stand part. Those of that opinion will say aye. Aye. Contrary, no. The ayes have it. Party votes called for. I'll ask the clerk for a party vote.
New Zealand National.
58 votes in favour.
New Zealand Labour.
42 votes in favour.
Green Party.
9 votes opposed.
Act New Zealand.
4 in favour.
Māori Party.
3 in favour.
Progressive.
1 vote in favour.
United Future.
1 vote in favour.
Honourable Chris Carter.
1 opposed.
Any other votes?
Members, the ayes are 109, the noes are 10. Part 4 as amended will stand part. We now move to the schedules. First we have the Minister's amendments. The question is that the Minister's amendments set out in SOPs number 202 and 244 be agreed to. Those of that opinion will say aye. Aye. Contrary, no. The ayes have it. The question is that Schedule 1 as amended stand part. Those of that opinion will say aye. Aye. Contrary, no. The ayes have it. We now move to Schedule 2. We have the Minister's amendments. The question is that the Minister's amendments set out on SOP number 202 be agreed to. Those of that opinion will say aye. Aye. Contrary, no. The ayes have it. The question now is that Schedule 2 as amended stand part. Those of that opinion will say aye. Aye. Contrary, no. The ayes have it. We now move to new Schedule 2A. We have the Minister's amendments. The question is that the Minister's amendments set out on SOP number 244 to new Schedule 2A set out on SOP number 202 be agreed to. Those of that opinion will say aye. Aye. Contrary, no. The ayes have it. The question now is that new Schedule 2 is amended be agreed to. Those of that opinion please say aye. My apologies. I'll just repeat that again. The question is that new Schedule 2A as amended be agreed to. Those of that opinion will say aye. Aye. Contrary, no. The ayes have it. We now move to new Schedule 2B. The question is that new Schedule 2B as set out on SOP number 202 be agreed to. Those of that opinion will say aye. Aye. Contrary, no. The ayes have it. We move to Schedule 3. First we have the Minister's amendment. The question is that the Minister's amendment set out on SOP number 202 be agreed to. Those of that opinion will say aye. Aye. Contrary, no. The ayes have it. We now move, the question is that Schedule 3 as amended stand part. Those of that opinion will say aye. Aye. Contrary, no. The ayes have it. And we now move to Clauses 1 and 2. The question is that Clause 1 stand part. Those of that opinion will say aye. Aye. Contrary, no. The ayes have it. We have the Minister's amendment set out on SOP number 202. The question is that the amendments be agreed to. Those of that opinion will say aye. Aye. Contrary, no. The ayes have it. The question is that Clause 2 is amended stand part. Those of that opinion will say aye. Aye. Contrary, no. The ayes have it.
Mr Chairman.
The Honourable Simon Powell.
Mr Chairman, I move supplementary order paper number 243, dividing the bill.
The question is that the motion be agreed to. Those of that opinion will say aye. Aye. Contrary, no. The ayes have it. I will report this bill with amended and so divided presently. Members, we now move to the Weathertight Homes Resolution Services Financial Assistance Package.